Good morning and welcome to the 29th meeting of the Constitution Europe External Affairs and Culture Committee in 2025. Our only public item on our agenda today is to begin taking evidence on an inquiry into a legal mechanism for any independence referendum. And this morning we have received apologies from Dr Daniel Cetra, but we are joined in person by Professor Adam Tomkins, John Millar, Professor of Public Law at Glasgow University, Professor Stephen Tierney, Professor of Constitutional Theory from the University of Edinburgh, and Professor Aileen McHarg, Professor of Public Law and Human Rights at Durham University, and a warm welcome to you all. I wonder if I could open with a general question, as your submissions provided for today outline some international examples of constitutionally regulated secession processes. But I would just seek your views as to whether these are a significant enough alignment between any of the examples and the UK's constitutional arrangements which may inform a potential legal mechanism for a referendum. And perhaps I could begin with Aileen.
Thank you. So I would say that the UK's constitutional arrangements are extremely flexible. So you could design almost any process for independence or route to independence that would fit with our constitutional arrangements, provided that it was one that at some point had the sanction of the UK Parliament. That's really all that you require. So the UK Parliament could delegate steps in the process to other institutions if it wanted to, or it could retain all the powers for itself to authorise referendums to determine the trigger conditions and so on. And we obviously, one of the examples I use, which is not an international example, but is an example of a regulated secession process, was Northern Ireland. So we do have an example within the context of the UK Constitution. I think it is worth pointing out, of course, that sovereignty of the UK Parliament means that nothing is ever absolutely binding, and the process under the Northern Ireland Act does not actually purport to bind the UK Parliament. It places obligations on the Secretary of State to lay proposals before Parliament if there is a vote in favour of Irish unification, but it doesn't bind the UK Parliament to accept it. But if the UK Parliament were to deny a clear expression of the people of Northern Ireland to leave the UK, I think that would be enormously problematic, and it's very difficult to imagine that happening. So I think the existence of a legal route within the context of the UK Constitution doesn't ultimately change the fact that things can, that it is a political matter and things can be changed, but it does change the terms of political debate. So I think that's one reason why there is quite a lot of search around for some sort of legal route, because that doesn't provide guarantees, but does change the nature of the debate that we would be having over the right of Scotland to become independent.
Thank you. Adam, would you like to?
I don't actually have anything to add to that. I agree with everything that Professor McHarg has just said. I should say, Convener, that yourself and members of the committee will know me in a different capacity, but I'm not here in any party political capacity today, just in the same way that Stephen and Aileen are here, just trying to help the committee with our understanding of the Constitution as best we can.
Thank you. Stephen?
Yeah, the thing I would add, given that reference has been made to international examples, I think one point of maybe category distinction is between a constitutional question and a state question. Very often this is talked about as the constitutional question, independence. And when we look at other countries, I think they clearly distinguish constitutional change from the issue of breaking up the state. So when we look at the American example, the American Constitution has clear mechanisms for amending the Constitution, even for rewriting the Constitution. But the Supreme Court there has distinguished that very clearly from secession, which it has said is a different issue. It's not about changing or rewriting the Constitution, it's about leaving the entire state. And they've ruled that to be unlawful. I think I cited the German Constitutional Court as well, when an issue involving Bavaria, and they make a very similar distinction between constitutional change within the German federal constitution and breaking up the state. So I do think, and maybe we'll come back to some of these issues later in terms of the distinction between that, but I think that's important. Within the United Kingdom, we've tended not to put much weight on that distinction, and it's generally agreed that on the basis of consent, it is possible for parts of the United Kingdom not only to argue for change, for devolution and so on, but to leave the state entirely. But I think the international precedents or comparators are interesting in the first instance for drawing out that distinction, which we don't always do in the United Kingdom.
Okay, thank you.
Can I just add one thing to that,
Yeah.
if you don't mind, Camina? I think it might be, I think what Stephen says is absolutely right. But I think it might also be helpful to bear in mind that a number of different ways in which law and politics can be distinguished from one another. Right? So there cannot be independence for Scotland or any other part of the United Kingdom without legal instruments, without an act of Parliament. But the process by which you might eventually get to that legal instrument is a political process. So, you know, the process of secession would require both political campaigning and political results, as well as legal instruments. And there would be legal instruments that would be required in order to set some of that process up, as there were in 2014. And there would be legal instruments that would then be required in the event of any kind of yes vote here or anywhere else in the UK for independence or for reunification of Ireland or whatever it might be. So as with so many areas of constitutional governance, if you will, political processes and legal processes and political campaigns and legal instruments are intertwined. And when we think about the Constitution in the round, we need to think both about the law of the Constitution and the politics of the Constitution. And I don't mean party politics, I mean political processes such as campaigns and debates and so on and so forth.
Okay, thank you. I'm going to move to questions from the committee. I'll bring in Mr Brown first.
Thanks and good morning, panel. Looking at the submissions, and we've also had a chat with some advisors to the committee, all of whom are as esteemed and as knowledgeable as the panel here. The one that stands out actually is Adam's one, I think, and I don't want to overstate it, and you can correct me if I'm overstating it, to the extent that it talks about the people as being pretty central to this, which is often forgotten when we talk about legal and constitutional architecture and so on. But the simple fact is, and I think Professor Tomkins says at various points, this is the people that are decision makers here. Now, whether it's in the case of trying to force the issue of having a mechanism to achieve independence or to stay in the Union, or whether it's actually taking that decision, I think that is very true. And I think it's also true to say, having worked in the EU for a number of years in the Committee of the Regions and now the Council of Europe, which is often said to be bound by its constitutional and legal architecture, it will follow the people very often. You know, the people are pretty supreme in relation to that. That seems to be relatively absent, apart from Adam's submission. Is that because of the way you were asked to contribute to this? For example, it's about finding a legal mechanism, or I don't know if, other than Adam, who's made his position clear, if either Aileen or Stephen would want to say something about the extent to which the people are pretty important in all this.
Thanks. Well, I think I did say in my submission that there was lots of political recognition of a right to self-determination or popular sovereignty or right to decide, however you want to call it. And I think that's really important. I would absolutely agree with Adam that that's important. And I quite liked his analysis of the kind of, that we'll recognise that this is going to be a question of settled will, and we'll recognise it when we see it. I think that is probably right. I think if it becomes kind of impossible to deny that that's what the people of Scotland want, I think that there will be a second referendum. I don't think we'll get to a second referendum of the nature of the 2014 referendum, which was really very much a process of opinion forming. For various reasons, I don't think that was a unique and one-off situation. But I think we will get to the situation where a second referendum, or we might get to the situation where we get to a second referendum as a confirmatory referendum, as the 1997 devolution referendum was a confirmatory referendum of an already established and clearly evidenced will for the people of Scotland to have their own parliament. So yeah, I do absolutely think that is where the energies of independence campaigners should be directed. They are, in my view, wasting their time looking for a kind of legal route to independence. That what is required if they want Scotland to be independent, they need to persuade a significant majority of the people of Scotland that that's the best constitutional route.
Yeah, and I did consider the invitation as a legal scholar, that I was principally being asked here, as you say, Mr Brown, to discuss the legal situation on two levels. It struck me that we were being asked to reflect upon the international law position to some extent, in particular the international law principle of self-determination, which does exist. And I felt it was important to lay out my understanding of what the international law position is, and also what the courts have said, the Canadian Court, Supreme Court, and the UK Supreme Court, which endorsed that position. So I felt that was important to put that on record, as I understand it, as a legal scholar and a lawyer. And secondly, the internal constitutional question. So I've distinguished those 2 points in my opening submission. I felt it was also important to explore what the Supreme Court of the United Kingdom has said on interpretation of Section 29. In terms of the popular consent, the third question really was about political accountability and the right of people to campaign for things. I don't have anything authoritative to say on that. That it really is now, as far as I can see, given that the international law position is clear, the domestic law position, as far as I can tell, is clear, that it is now a matter for political debate. Do the Scottish people and do their political representatives have the right to campaign vigorously for independence? Absolutely. Do they have the right to make that debate and to engage and say it is a political claim and a political right? Absolutely. But in these submissions, I simply sought to distinguish that from what I saw as the legal position.
And just on that position, both from your submissions and from what we heard from advisers, sorry, when this inquiry came about, I had mentioned the fact that if the Act of Union is said to be democratic and voluntary, how can that consent be exercised in relation to that? But from what you're saying, and I know that Aileen's mentioned it in her submission, and from what we heard from the advisers to the committee, there seems to be the view, I could be wrong, that it's not that relevant, the Treaty of Union, as to the debate we're currently having, or am I getting that wrong? I don't know, Adam, if you want to...
I think that's right, Mr Brown. And I mean, again, just for the record, I agree with what Stephen Tierney and Aileen McHarg have just told the committee. I would just clarify that we're not talking about, there's a great deal of clarity in British constitutional setup about which people we're talking about. We're talking about the people of Scotland. In the context of Northern Ireland's constitutional future, we're talking about the people of Northern Ireland. In the context of Scotland's constitutional future, we're talking about the people of Scotland. And I know that there have been debates in the past about how that might be defined. Are we talking about the people who live here? Are we talking about the people who were born here? Are we talking about the people who were born here and might live somewhere else in the United Kingdom? And there are ways in which that can be tweaked, I think, largely unhelpfully. But it's perfectly clear as a matter of constitutional practice, as a matter of constitutional theory, as a matter of constitutional principle in the UK, that when we are thinking about questions of secession or independence for Scotland, the decision maker is the people of Scotland. And the question, I suppose, then is, what is the legal route or what is the political route towards which we can, that we need to follow in order to put that question to the people of Scotland? And those are the issues that we're trying to grapple with. And in answering those questions, I think you're right, Mr Brown, that there's nothing in the Treaty of Union that is particularly helpful or unhelpful. I think it's not where I would start my analysis, and I don't think it didn't feature in my analysis that I sent to the committee. I don't think any of us mentioned it, or if we did, only in passing.
I don't know if Aileen or Stephen want to come in.
I completely understand that there can be frustration sometimes with lawyers who present a legal position when it might not seem to tally with a preferred political position or even a point of moral principle that people think should apply. It does seem to me that the Acts of Union has always taken on rhetorical importance. It has always been something that people have referred to as 17.7 being a voluntary union. One of the reasons why legally we tend not to discuss it is that the courts have tended not, apart from in one case in the 1950s, to give much truck to it. Secondly, the Scotland Act itself makes clear that the Acts of Union going forward have effect subject to the Scotland Act. I think Section 37 makes that clear. So it has tended to pass out of discussion in a debate that's now really about the competence within the Scotland Act in relation to Parliament. But I think the popular question is an important one. And when I mention states like the US and Germany, one of the reasons why secession is so clearly outlawed there is they have a conception of one people. There is one American people, there is one German people, and that is that's universally accepted. Therefore, secession becomes effectively impossible. In the United Kingdom, we haven't done that. Rhetorically, politically, morally, we have continued to accept that the United Kingdom is a multinational union. And on that basis, Scotland and the Scottish people are recognised as distinct. So when I say it's just a political debate now, it's not an unbounded political debate. It's a political debate that takes place within that context of Scotland and the Scottish people being recognised as a distinct and important entity, the way they are not, the way equivalent lander or states in America are not recognised as people. So there is a very important, I think, political point in that. But it is ultimately a political point that has to inform political debate. It doesn't directly inform the legal debate.
Yeah. Okay. So yeah, I mean, I tend to agree. I mean, the importance of the Treaty of Union, I think, is in having sustained the idea of Scotland's separate nationhood, which then becomes reflected legally in international law terms that we are recognised as a people with a right to self-determination. Now, it doesn't tell us what self-determination means, but that basic question that Scotland is a people is not really contested. But as has already been said, legally, it doesn't really help us, not least because, of course, the Treaty of Union states that it is to last forever, which could be interpreted, if you were so minded, as a constitutional ban on secession, but it hasn't been treated like that. The Irish Acts of Union, which were also supposed to last forever, did not stop the formation of the Irish Free State, and which became the Republic of Ireland. The specific argument that I've seen made recently relates to the claim of right of 1689, which is one of the kind of guaranteed provisions of union, and it's argued that that creates a right to popular sovereignty. I mean, it simply doesn't do that. The claim of right, it could be seen as, well, it does confirm an idea which was contested in 17th century Scots constitutional law about the nature of monarchical power, and it confirms that contractual monarchy or limited monarchy won out over the divine right of kings. And that has been linked to ideas of popular sovereignty. But there's nothing either in the claim of right itself or that I've been able to find in pre-Union Scottish constitutional history that in any sense resembles a legal doctrine of popular sovereignty or a legal mechanism for triggering popular sovereignty. So again, that is politically important. It has helped to sustain our relative autonomy within the Union, but it doesn't give you a legal trump card that could be used to overcome the much clearer modern authority that, as Stephen says, is based around the Scotland Act and the sovereignty of the Westminster Parliament.
Thanks very much for that. On the legal route, we had evidence about St Kitts and Nevis. However, and I could be wrong on all this, I'm happy to be corrected, there seems a more recent precedent, which is the Turks and Caicos Islands, which I think the UK government passed law last year, which allowed the Turks and Caicos Islands to both have a referendum and to move on to its independence if it chose to do so. Now, I'm just stating that because I'm sure I've heard that from somewhere. It'd be interesting if any of the panel have anything that they know about that particular situation at all.
I would be very cautious indeed about analogizing from the position of former colonies to Scotland's position. I don't know anything about the details of the processes with regard to St Kitts or Turks and Caicos, so I can't give the committee any help on the detail of that, other than the general principle that which is reflected in all of the authorities that we've brought to the committee's attention, including the Quebec secession referendum, the Quebec secession reference, and the UK Supreme Court's decision in the Lord Advocate's reference. It makes very clear that any international legal right to self-determination obtains in specific contexts, including colonialisation or decolonialisation and oppression, and those conditions plainly don't obtain in Scotland's case. Whatever we think about Scotland's current constitutional arrangements, the Scottish people are not oppressed, and Scotland is not a colony of any kind of British Empire. On the contrary, Scotland was part of the imperial force, as you know. So I would just be very cautious about analogizing from that context to ours.
Well, can I just say that I'm pretty sure the UK government would not expressed the reason for them granting that authority in terms of a former colonial possession. That's not on the basis on which the UK government would do that. And I don't think the case for it is based on its status as a former colony. I don't know what the status is just now. It might be Dominion status, I'm not sure which. I'm pretty sure the UK government wouldn't have justified its actions in terms of an ex-colony, but I take your point.
So, I mean, like Adam, I don't know the details of the Turks and Caicos situation. It is a colony. It has a Governor-General, and there are... The process of decolonisation is not only one of the cases in which a right to so-called external self-determination is recognised, i.e. the right to become independent. It is also subject to quite detailed, specific procedures in international law which impose obligations on all states, including the host states, to facilitate the process of decolonisation. So I would agree with Adam that we're just not in that. We're not in that space. There are attempts to argue that we're in that space, but I think they are wholly misconceived in terms of our constitutional history. We are an integral part of the UK state. We are not a colony.
Maybe it's me that's introduced to confusion. I don't think that's what's happening here. This is not an appeal by the Turks and Caicos to the UN or international bodies based on its origins as a colonial state. It goes to the point we're making about if the UK government decides it wants to allow for the expression of self-determination, it can do it itself, and it's done it itself on this basis. I don't think it's part of as best I know, a wider campaign. Can I just ask one last question, which is, we've heard a lot of discussion, obviously, in this debate about the once-in-a-generation idea. Now, it was said by a couple of very prominent people, at least on a couple of occasions, I think, probably misinterpreting what was being said. But it now seems to be almost elevated to like a constitutional convention, whereby it's a cast iron law. And if you were to do that, if you thought about the 2016 Brexit referendum, if you think about the 2014 referendum, when it was said that the only way to secure Scotland's place within the EU was to vote no, and that's not being continued on as a kind of constitutional convention. What is your view of this once-in-a-generation kind of tenet?
So it's political rhetoric, not constitutional convention. And I don't mean to demean it. I've engaged in plenty of political rhetoric myself in the past. But that's what it is, right? It's certainly not a rule of constitutional law, subject to one exception, which I shall come to in a minute. It's not even a constitutional convention. The statements that were offered in the 2014 campaign about once in a generation, if not once in a lifetime, were political statements and should be taken as such, in my view. It is obviously, self-evidently, not the case that in the United Kingdom, once you've had a referendum on an issue, you can't have another referendum on the same issue sometime later. There have been 2 referendums on the UK's membership of the European Union, and they were, I'm not very good at maths, but from 1975 to 2016, 41 years apart. There were 2 referendums on Scottish devolution, and they were 18 years apart. The only statutory reference to anything pertaining to this, and it's not a reference that uses the term generation, is in Section 1 and Schedule 1 of the Northern Ireland Act, which provides that there cannot be what that legislation refers to as a border poll within 7 years of the previous one. So there is no legal answer to the question, how long is a generation, because it's not a question of law. But there are, if you will, small p precedents that you can point to that say that somewhere between 7, 18 and 41 years might give you some kind of sense of the answer as to how long a generation might be.
I don't know if Aileen or Stephen want to come in on that.
I completely agree with that. Maybe just worth pointing out that under the Northern Ireland Constitution Act of 1973, the minimum period between border polls was 10 years. So if we're talking about statutory ideas of what generations are, they're actually quite short. It is a opportunistic interpretation of campaign rhetoric, which for me, it seemed to be about encouraging people to vote because they might not get another chance, rather than any sort of intention to create a promise. You wouldn't seek another one for a generation, whatever that is. So, the other thing about that, of course, is that once in a generation argument loses force the longer it's been since 2014. So, we might expect other types of arguments, other types of reasons for rejecting a second independence referendum have been used anyway. I mean, for Theresa May, it was simply now is not the time. For others, it was public support is not high enough, or there are higher priorities like dealing with the pandemic or climate change or whatever it is that people want. These are, and this is one of the features of our lack of legal regulation. There are no trigger conditions. There are no limiting conditions. It is simply a question of when the time is right.
I think the thing about a constitutional convention is it is important. Constitutional conventions in our system, because our system is so fluid with Parliament able to do what it wants, the UK Parliament, conventions take on particular significance. And they are rules. And this is important. They're not just political claims. And the rules that the people subject to them feel bound by. And they feel bound by them not just politically, but constitutionally. They feel, I must behave this way in order to act in conformity with the Constitution. And that's really important. And I don't think, therefore, we can't find new conventions easily. They have to emerge over time through precedent and through clear evidence that the people who are subject to them feel bound by them. So it's quite a high hurdle, and I can see no evidence, as Adam and Aileen have said, to suggest that a political claim of that nature could in any way be considered to be a constitutional convention. Even where it's so, we now know constitutional conventions would not be enforced by courts. But that's not to say it's not important. Were there such a convention, I would say it's very important. But I can't see in that political claim the structure of a convention.
Thank you.
Thank you. Looking to Mr. Calcro Johnson.
Thank you very much, Convener. Just on that, I don't want to kind of labour the point, but I think it's worth clarifying, because I think this issue around the only way of staying in the EU is to vote to stay in the UK is a point that's been misrepresented repeatedly. The European and External Relations Committee were written to by the Commission highlighting that leaving a member state would be this would mean leaving the European Union. So the point actually was I think, made by the European Commission. And also the once in a generation, which I absolutely agree in terms of the precedent or the lack of precedent it provides, was actually part of the Scottish Government's white paper. So it wasn't just two prominent people, albeit that they were the First Minister and then the following First Minister. The question that I was going to have was regards to settled will and some of the opinion and how you might get to that stage where you determine what the feeling of the Scottish people are, because we've we've talked about the people. What's your, I suppose, definition of settled will? How does that fit in? If I can ask, perhaps Professor McHarg first.
I mean, I think it's not something. It's like a generation. It's not subject to any precise definition. I mean, I think. Why did we think that devolution, by the time of the 97 referendum, was settled will? Well, because public opinion polls consistently showed high support for it, because there was cross-party support for it, because there had been the Scottish Constitutional Convention, because it was a big topic of debate. I mean, I don't think I don't think you can define it any more precisely than that, and I think it would be a mistake for anyone to put a precise number on it, because you can tie yourself down. Fluidity, and constitutional silence and all these things can be very, very useful in trying to deal with these kind of big existential questions that we're talking about today. So, it's also like saying that if the SNP or presumably some other pro-independence party were to win another overall majority, then that's the trigger. And that's the only trigger. That that's not very likely to happen. So it doesn't seem to me to be very sensible to kind of, if you want another referendum, to tie yourself down to something like that. So I think this is inevitably fluid, and I think there are advantages in it remaining so.
Thanks. I mean, if I can just come in, I mean, obviously a number of panelists talked about the flexibility of the Constitution. I think Professor Tomkins, you mentioned that as well. And that, I suppose, was one of the difficulties in how we determined that opinion, that will, that idea of what the Scottish people want, because opinion polls fluctuate. I mean, even when we talk about devolution, I think it's 21% of people in Scotland would happily abolish Holyrood, according to YouGov polling last year. That doesn't necessarily suggest, obviously, that there's still a demand for the Parliament, but that could change because obviously independence started on a low base itself. I'm not advocating for that, by the way. Just walking, but it is interesting, I suppose, how you determine how much weight you put in behind opinion polls. We know that there's a fairly relatively equal, depending on which polls you take, opinions on independence, but of course it's not a priority. How much do you give as a weighting for priority of another referendum or independence of the thing? And just that seems to be a fairly difficult to kind of pin down aspect of this whole debate. What do actually people in Scotland want, and how will you ever determine and be able to rate that?
Yeah, so there isn't a clear answer to that. I mean, I completely agree with what Aileen McHarg just said. I mean, it is a bit like defining generation, right? It would be better not to, because the great advantage of the system that we're in is its flexibility or its fluidity, as Stephen Tierney referred to it a few moments ago. The downside of all of that is a substantial dose of vagueness, right? But as I say in my written submission, if that upsets you and you want more precision, be careful what you wish for, because the international evidence is that the clearer you are in your constitutional arrangements about laws relating to secession, the harder secession is. So I know not everybody in the room wants to see an independent Scotland, but those who do want to see an independent Scotland should, in my opinion, be careful about pushing too hard against the vagueness. The vagueness is frustrating, right? Stephen Tierney talked about people being politically frustrated with the constitutional arrangements. I understand all of that. How do we tell what the settled will of the Scottish people is? There is no one test, right? It's not one election result. It's not even one series of election results. It's not a party political judgment, right? It's not quite a matter of consensus. It's not the case that everybody in the room would have to agree. But this is where what is sometimes colloquially called losers' consent also also really matters, right? There were people in 2012 who did not want an independence referendum, but they recognised nonetheless that the time had come for an independence referendum to be held. There were people in 1997 who didn't want devolution, but they recognised that devolution had clearly by that point become the settled will of the Scottish people. And neither of those positions has ever really been contested. That's the kind of place that you need to get to in order to show that there is settled will. And you know, settled will can be changed. Clearly, the settled will was changed with regard to devolution between 1979 and 1997. It was changed not just by party political campaigning, but by non-party political campaigning. It was changed by momentum, right? And the only word I wrote down in my notes here when Aileen was speaking, that I would add to what Aileen said, is momentum. Right? Settled will is a reflection of the fact that the momentum is now behind an idea or a project or a reform or a change. Okay, there doesn't seem to be a great deal of evidence of that with regard to independence yet in Scotland. As I say in my written submissions, you know, it would clearly be contrary to the settled will of the Scottish people for anybody to take independence off the table, right? But equally clearly, it seems to me to be only a minority position at the moment that independence should be pursued as a matter of pressing priority right now. So it seems to be the case that people want independence on the horizon, but no closer than that. Thank you very much. But that's just my estimate as a citizen, right? That's not an expert view. How do I know that? From talking to people like you do, from opinion polls, which I can read as you do. I think it is. I mean, I think Aileen used this phrase earlier in her submissions this morning. We will know it when we see it. That is completely unsatisfactory as a matter of definition, but it is probably the best we can do.
Okay, Professor Tierney?
I wouldn't try and quantify the idea of settled will or what it should, how it should impact on political actors. The thing I would maybe refer to is settled will to do what? And the independence question, I'll come back to earlier remarks, is to my mind a categorically different question from the creation or extension of devolution. Constitutional change in our country happens very easily. We saw that in the creation of devolution, we saw it in the 2012 Act, the 2016 Act, all of the legislation for Wales. Constitutional change on territorial questions happens very straightforwardly. There are two distinctions between the creation and extension of devolution and what we're talking about here. The first is that those are reversible. If you do try something in the 2012 Act or the 2016 Act and it doesn't seem to be working, the UK Parliament can then legislate or go through the same process and we can go back to where we were. That's not the case with independence. Independence, if it happens, is a category and abrupt and significant change, not just to the Constitution but to the state. Secondly, those involved in the decision are not simply internal. When you change your constitution, generally the international community doesn't want to know, provided you don't introduce constitutional standards that violate international law. When you secede or break away from a state, you involve others because there's the law of state succession, who succeeds to legal personality. There's also the issue of recognition of the new state. The international order has also, at various points, emphasise the importance of territorial integrity and the stability of states. I'm not saying for a moment that those are insurmountable hurdles to Scottish independence. All I'm saying is that all of that together raises independence or secession to a categorically different level from increasing devolution or even turning the UK into a federal constitution. Those are internal constitutional changes. So when we talk about settled will to do something, I think we have to be quite careful not to think there's a easy continuum from settled will to extend the powers of the Scottish Parliament and the settled will to break up the state. I think there has to be a recognition that these are categorically different decisions. I'm not saying it shouldn't be allowed or it's unlawful or it's immoral or anything like that, but I think we have to be careful about what we're talking about when we talk about settled will.
Okay, that's actually covered a couple of the points, so I'll maybe come back in later.
Thank you. Patrick.
Thank you, Convener. Good morning, everyone. I appreciated the frankness a moment ago there from Adam Tomkins about this, we'll know it when we see it, being, I think you said, it might be the best we can do, but it's clearly inadequate. And maybe in this interface between the the legalities and the politics, maybe it's not possible to have a position that's free of contradictions like that. I wanted to pick up on a couple of points about more general use of referendums in Adam Tomkins' paper, and I'd be interested in everybody's views about it. So several referendums that are not about secession are mentioned, and you make the case that we should use referendums not to determine or to find out the views of people on an issue, but to establish what we already think we know. But you gave some examples, including, for example, the referendum on AV as being one which successfully settled a question. I would push back against that a little bit. It didn't settle the question of whether electoral reform is necessary. You know, perhaps the Lib Dems not being here would push back against this, but they skillfully negotiated a coalition agreement which gave them a referendum on a voting system that nobody wanted. It wasn't anybody's choice, the AV system. So it was almost designed as a scheme to put electoral reform on the back burner. But it didn't settle the question of whether it was required, and with the genuine prospect of a far-right government in the UK now, that should be sending chills down all our spines. So I think I would ask for a reflection on perhaps other countries that use referendums more frequently on non-secession issues. Ireland, for example, has a range of referendums on issues where they didn't really know how the public was going to vote. You know, common sense might have said that the public would have supported doing away with some of the misogynistic language in the Constitution in the recent referendums on family and care. But those expectations were confounded, and the public voted quite comprehensively to keep that, what I would consider archaic language. So surely there is a case for using referendums to ask genuinely, what is the view? And is there a 50% plus one majority, rather than to establish that we already know there's an overwhelming settled majority? And should we learn from Ireland's experience of having some level of direct democracy as the trigger point for putting those questions to the public? Ireland used citizens' assemblies in a number of instances to determine questions that the political process either couldn't resolve or was in deadlock over.
Those are very fair questions, Mr. Harvey, and thank you for them. I think, in broad terms, I would agree with you. Right? I mean, I think there are as many different styles and types of referendums as there are referendums that have been held. And what I'm trying to do is to learn from best practice. I think, and I'm not sure that this is. I think I'm saying this just as a private citizen rather than as a professor of constitutional law, but I think it would be a shame if we hadn't learnt from the mistakes of 2014 and 2016. I don't think either 2014 or 2016 were particularly happy referendum experiences. And by that I mean that they didn't do everything that was asked of them, right? What was asked of those referendums was that they were fair, legal and decisive. Well, they were fair, probably. They were legal, certainly. But they didn't really settle either of the issues that they were asked to settle, did they? I mean, we're still here. We're still talking about independence, notwithstanding, and processes towards independence, notwithstanding. So perhaps you disagree, but I'm just telling you how I honestly see it. And I think that the contrast between the 2014 referendum in Scotland and the 1997 referendum in Scotland could not be greater. Right? I don't think there's any coherent argument is there that the 1997 referendum in Scotland did not settle the question that we want devolution. And I'm not altogether sure I agree with the evidence that Professor Tierney just gave the committee about saying that independence is somehow categorically different in terms of thinking about settled will from devolution. I'm not sure that categorical difference would be reflected in any source of constitutional authority. So I'm not entirely sure about that. So I would read across from settled will with regard to devolution to settled will with regard to independence. I wouldn't set the bar higher or differently so that's perhaps a disagreement between the two of us. But it's certainly the case that we can, if we want, try and learn from experience of other jurisdictions with regard to referendums, and Ireland might be one example, California might be another example, Switzerland might be a third. I would be cautious, though, right, for two reasons. One, path dependency, right? I mean, we're not Ireland or Switzerland or California, and our experience has shaped what we think of referendums, and Ireland's experience has shaped what Ireland thinks of referendums, and our experiences have been different. So path dependency, I think, becomes quite powerful. But also, I'm generally allergic to kind of constitutional transplantation, right? I mean, I think constitutions, particularly constitutions like the British Constitution, happen from the ground up rather than from top down. And so, but if you put all of that together, what I think I'm trying to suggest in my evidence is that there's a better way of doing an independence referendum than what we did in 2014. And I think it's a way of doing an independence referendum in the future, which is more likely to happen than not. And that is that we ask the question only after we have already pretty much determined what the answer is going to be. And that is not what happened in 2014. It is what happened in 1997. And I think that, if we want to learn from our experience, if we want to learn from our experience of holding referendums, then we might want to try and emulate 1997 more than we want to emulate 2014.
I mean, I see others wanting to come in, but one part of what was different was that there was a very clearly defined proposition being put rather than a general one. And I would suggest that one of the reasons why 2016, the EU referendum, resulted in such chaos was that every flavour of Brexit imaginable was on offer, not a clear, defined, solid proposition. And that's what led to a lot of the chaos. But if the result had been no, I don't think for a moment the Brexiteers would have gone away and spent the next decade saying, oh, well, we lost that one, let's talk about something else.
I'm not holding up 2016 as a good example to emulate. I'm holding it up as a bad example to try and avoid.
Yeah. Can I see Aileen McHarg wants to come in as well. Can I also just kind of remind where I finished my first question was, should there be some discussion about the potential for a direct democracy element, some kind of way in which the public can themselves assert we're ready to have this question put, or a substantial body of us are ready to have this question put as a way of kind of doing a bit of an end run around the political deadlock.
Yeah, thanks. I mean, the point I wanted to make was just to slightly disagree with Adam, because I think he's conflating two different issues. One is about the concreteness of the proposal, as you say, and the other is about how sure you are about how the public will vote on that. I mean, if you compare the two devolution referendums, the 79 referendum was on a much more concrete set of proposals, because it was after the enactment of the Scotland Act 1978. That didn't settle the question at all, because we had another referendum 18 years later. And in relation to the question of independence, I mean, we were talking before we came in about a sort of sense of déjà vu, but I remember lots of discussions about whether we should have one referendum or two referendums, and when the referendum should take place in 2014. It seems to me that on something as big and important as independence, waiting until there is a concrete set of proposals, which is really a question of negotiation, would be between the Scottish Government and the UK Government. That is a bit late to be asking the Scottish people, do you really want this? So I think in these contexts, actually something on the principle is unavoidable. On your question about should there be a kind of democratic element triggering the process, so you could design you could design a secession process, and the Ethiopian constitution provides an example of this, where there is a trigger process by the territory wishing to secede. There needs to be a vote in the appropriate legislature, and then that triggers a duty on the federal government to organise a referendum. So you could design a process that is like that. the difficulty, I mean, and to get back to concrete, to our concrete legal position is the reservation of the union, as the Supreme Court confirmed in 2022, could stop the Scottish Parliament, the Scottish Government doing other things that might have that triggering effect. The Supreme Court decided that a referendum related to the union not because it had any legal effect on the union, but because of its political effect on the union. So that creates an area of uncertainty about, well, what degree of political effect are we talking about here that would bring something within the reservation of the union. So I think there are real uncertainties there about what could be done.
But if we were to move the question about some kind of direct democracy element away from secession, away from independence on its own, and towards simply the question of how do the people of Scotland assert their right to make a decision on a matter of importance that the political process is failing to engage with. Isn't that one way of giving a clear mechanism into the hands of the public that allows them to force the political process to respond?
Well, the difficulty is that none of these things are in and of themselves out with the competence of the Scottish Parliament. It's not out with the competence of the Scottish Parliament to legislate for referendums. Mm. It is out with the competence of the Scottish Parliament to legislate for a referendum on independence. So if you're talking about creating some other kind of direct democracy mechanism, that would also be subject to the competence limits on the Scottish Parliament. And as I say, I think that there is a degree of uncertainty about how far the Supreme Court would push that idea that the reservation of the union encompasses things that might have a political effect on the future of the union rather than a legal effect. It might say, well, referendums are something completely different and separate, and they have a particular political authority that puts them in a separate category. But you might see the opposite argument being made, particularly if it's perceived that what you're doing is trying to get round the reservation of independence referendums.
Could I say, I think it's a really important set of questions. On the first one, I think a few things very quickly. One is, when we talked about settled will, and I discussed secession as not just another constitutional question, but as at least a very big constitutional question and arguably category difference, I think a referendum is absolutely fundamental. I don't think there's another way to settle this issue other than by a referendum. And I think referendums can be done well. You were on that committee, Mr Harvey, back in 2012 that I advised on the independence bill, and I thought it worked very well and very collegiately. So I think there is a route there. I think, secondly, this idea about having a package to take to the people in the referendum about how things will look after it can be very important. I think Ireland is a really important precedent in another way. If we think of the referendum in Northern Ireland in 1973, which was largely boycotted by nationalists, and which simply inflamed what was already a very bad situation, compared to the Northern Ireland referendum of 1998, when both communities went to vote on a package they had all agreed upon, and therefore they weren't being asked the big sovereignty question. They were being asked to vote on the Belfast Agreement, and you got fairly broad consensus in favour of that. I think the model that Adam's talking about, where people go in a referendum to vote on the end deal, is ideal, particularly when society is either quite evenly split or where there's some deep divisions. The problem with that approach, of course, is it's a catch-22. If you're going to vote for independence, then you say we would like the UK to agree to what independence will look like. It's in the interest of those who don't want a yes vote not to agree to a package. It was the same with Brexit. If the UK, if the Leavers had gone to Brussels and said, please do the deal with us, the new trade agreement, before we have this referendum, Brussels would have said, no, of course we won't do that. It will just encourage a leave vote. So there's a catch-22 there. In an ideal world, you do get a kind of Belfast Agreement deal that you put to the people. But realistically, when it comes to the secession votes of 2014 and 16, which was realistically a secession vote, you're not going to get that. In terms of the second idea about how you get people together in some kind of deliberative enterprise to maybe agree about how they go forward, as a point of principle, I think that's a good one. The problem with these deliberative exercises is they very quickly become elite-driven. Elite-driven. It depends who sets them up, who sets the terms for them. We've seen precedents for this in Canada in terms of changing the electoral system within provinces. And they set up people's assemblies, citizens' assemblies, to discuss this. And it seemed like a very good idea. Either you get the point that political elites determine how those processes go, or experts come in and they determine how the process goes, or the Citizens' Assembly come up with a scenario that, in the end, is entirely unrealistic to the political class, who say, well, this wouldn't run, and that actually happened in terms of the electoral system that was produced in Ontario. So I can see the point of an intermediate step where you would get some kind of deliberative popular discussion, and I think a deliberative popular discussion is always a good thing. But there is a danger in setting these things up, that those who set them up path determine how they go, and you have to be really careful about that.
Can I just make one other point about that? I mean, we have had a citizens' assembly in Scotland about what kind of wasn't the question what kind of Scotland do we want Scotland to become, or what kind of country do we want Scotland to be, or something like that.
There was one on Scotland's future, which was a bit vague and undefined. There was another on climate, which I think perhaps fell into the category that Stephen Tierney was talking about there.
So just a couple of very quick
solutions that weren't all entirely
so just a couple of very quick points about that then. I mean, I agree with what Stephen just said. I mean, I'm all in favour of democracy being spread in Scotland away beyond the representative model of this Parliament and our local authorities. I'm all in favour of that. I'm all in favour of participatory democracy being more widely experienced and being encouraged. And I think that if you want to do that in Scotland, you might be advised not to start with the constitutional question, right? Because we know that the constitutional question is divisive. Why not have a citizens' assembly about assisted dying, for example? Why not have a citizens' assembly about any number of really difficult moral, political questions, which our parliaments are, with respect, struggling to deal with at the moment? I don't just mean this parliament; I also mean the one in Westminster. This is clearly an issue that is really important to a lot of people, and it's precisely the sort of thing that we could have a citizens' assembly about. So I think that if you want to think about participatory democracy, I would be inclined to think about it as something which, if it's going to gather pace in Scotland, you might stand a better prospect of it gathering pace if you took it away from the constitutional question. And then just on Aileen's point about legislative competence, I mean, I'm not sure that citizens' assemblies require an act of the Scottish Parliament to set them up. I don't think the ones that we've talked about just in that exchange, Mr. Harvey, did require legislation, did they? And I don't think that there's anything in the 2022 Supreme Court judgment to suggest that the Scottish Government or the Scottish Parliament exploring ways in which to broaden participatory democracy in Scotland, even in the constitutional question, would somehow be out with competence. I wouldn't read the judgment in that way at all.
I know I've taken quite a lot of time on this, convener, but I think just to acknowledge that when I talked about some element of direct democracy, I wasn't necessarily meaning a citizens' assembly as the format for that, but I think it's still something I'd like to explore further as we go on.
Okay, thank you, Mr. Adam.
And good morning, everyone. It's nice to see Professor Tomkins. It's unusual seeing him at the other side of the table instead of here with the rest of us. Ironically, I'm following on in the back of, as a former minister that was in charge of referenda and participatory democracy, one of the things I would say, agreeing with Professor Tomkins, I think the two citizen assemblies that we had were too vague and too bigger questions, rather than actually breaking it down. Assisted dying would be a perfect example. When I came in as minister, I said, why don't we do one on assisted dying, the difficult questions, citing what Ireland did with some of the difficult questions they had. But that's entirely different from what we're talking about today. What I'm wanting to talk about was, when I was there, I would be obviously talk to people that were pro-independence like myself, and they'll say, you're in charge of referendum, George. Just do it, do it. And I would cite many of the arguments that has been put forward today, saying you wouldn't gain anything, you wouldn't be any further forward, you would be in a Catalonian situation, and they would carry on that way. But if we're looking at it, and I'm taking on board the fact that Professor Tomkins said, be careful what you wish for, because the flexibility of the UK Constitution might be helpful. But one of the things that our advisors have already said to us previously was, they talked about the Canadian paradox, where effectively the UK Supreme Court took on one aspect of it, whereas Quebec couldn't actually enable a referendum on their own, be for the Canadian government, but they didn't do the next part, which was if there was clear actual process and reason that the political process got to a stage where they could do it, then there would be open dialogue and it would all be done in good faith. Would that kind of aspect have helped us here in this scenario, so that we weren't in that kind of no man's land almost, where we're having the continual access? So when, as every one of you have said, when that act happened and everybody knew we were moving forward politically with the argument, then there was the right for the UK government to negotiate in good faith and not just say, now's not the time.
Well, I mean, the duty on the federal government and the other provinces in Canadian constitutional law to negotiate in good faith is triggered only after there has been, as it were, a yes vote in the province that wishes to secede. It's not a duty to negotiate in good faith in the run-up.
But Adam, we can't even get to that stage at this stage politically. That's the situation. We do know that there's a majority of Scots believe in independence, so you know we can't. That's where the frustration comes in, because there isn't that ability for us to go forward.
So, look, I mean, it's not for me to advise nationalist politicians about what they should do in terms of trying to establish that it's the settled will of the Scottish people to pursue independence, except to say that is, with respect, your job. I mean, that if you want independence for Scotland, and I know you do, then your job is to try and persuade the people of Scotland to embrace that, so that it becomes manifestly the settled will of the Scottish people. And then, as you've heard all three of us say, you know, any United Kingdom government or parliament that seeks to frustrate that settled will is going to be paying a significant political price. Okay. And I know that you want more clarity than that, but I can't give it to you because I don't think it exists.
Okay, anyone else? As he grasps its
in a nutshell, and I hope this isn't an oversimplification, the way I see the Spain, Quebec, UK situation, Catalonia can neither hold a referendum nor get independence, even if they held a referendum. So they're excluded on both things. Quebec within Canada can hold a referendum. It has a constitutional right to hold a referendum whenever it wants, but there's no constitutional right to secede even in the event of a yes vote. That has to be negotiated. Scotland's in the reverse situation of that, in that there's no right of the Scottish Parliament to hold a referendum, but there is a generally accepted political principle that where there won on a yes vote, that would be effectively an automatic right to go. It would have to be negotiated, but the principle would be conceded. So the hurdle in Scotland, you're right, is the referendum, but the principle of secession is there. Quebec's the reverse, as I see it.
So just to add, the situation in Northern Ireland is also that there is no role for the local devolved institutions. It's a question for the Secretary of State. However, in the Ree McHarg case, the Northern Ireland Court of Appeal did say that the Secretary of State had to exercise their functions impartially, in good faith, and bearing in mind the right to self-determination of the people of Northern Ireland. Now, that is in the context of a statutory scheme, but you know, you could imagine similar arguments being made here at the political level, that this is not something that decisions should be taken on a partisan basis.
Okay. Thank you. Are there any further questions? Oh, Stephen.
Yeah, so our committee advisors earlier gave us the same sort of picture you're giving us. Basically, this whole discussion is fundamentally political. And Adam, you said, you talked about the vagueness. You actually described it as a strength of the British constitutional arrangement. It's vague. Can I ask you all to tell us what is certain about the legalities surrounding the constitutional arrangements we have in these islands? what is certain in law, because that is your area of expertise. Adam, why don't you go first? Tell us what's certain.
That's a horrible question. What is certain is that all sides of the argument agree that the decision maker is the Scottish people. All sides of the argument, I think, agree that the test is what is the settled will of the Scottish people. And all sides of the argument accept, for the time being, that there is no route to a referendum to test that settled will without the consent of the Westminster Parliament, either under an Act of Parliament or a Section 30 order, as was granted under the Edinburgh Agreement in 2012. And all of that, I think, is either expressed in or can reasonably be implied into the Supreme Court judgment from 2022. So that is what is certain. And I think that when understood in comparative terms, and we've talked about Germany, we've talked about the United States, we've talked about Spain, we've talked about Canada, Aileen's talked about Ethiopia, which is a jurisdiction I know nothing about, and we've talked about Northern Ireland. When understood in comparative terms, that is a notably permissive approach for the UK Constitution to take towards secession. I think I would leave it at that.
Okay, that's fair enough.
I would say two things are clear as a matter of law. One is that there is no right to secede under international law. It's not a prohibition against secession, but there's no right recognised under self-determination that would require international intervention. But no one's really taking that argument seriously. The question really fundamentally is the internal one. And I hope committee members will realise I don't approach this answer to the question, which I think is clear, in any way from a partisan position. In 2012, I published a blog arguing that there was a plausible legal argument that the Scottish Parliament could stage a referendum on independence. In 2012, I believed that to be the case, that there was at least a plausible argument. I no longer believe that to be the case. As far as I'm concerned, the UK Supreme Court has now crystallised very clearly what the legal position is. It's outside competence for this Parliament to legislate in something that relates to a reserved matter. The Supreme Court has told us the Union is a reserved matter. We thought there was some wriggle room around Section 29(3) because you define a reserved matter by its effect in all circumstances. One argument was an advisory referendum might not have the effect of ending the Union. That's where the grey area was, and I thought it was worth exploring. It has now been explored, and the UK Supreme Court has said categorically there is no distinction in law between an advisory and a binding referendum. Both are beyond the competence of this Parliament. As I say, I don't say that in any way. I am not, and I've never been a member of a political party. I don't say that as a partisan point. But to me, as a legal scholar, the legal point now is crystal clear. Having said that, we live in a free and democratic society. The United Kingdom Constitution is characterised by that, and it is open to people to make a political argument. And there is now precedent politically to take forward the independence question politically. And that's free and open to people to argue questions about generation, settled will, and so on. But the authority of this Parliament to hold a referendum is now categorically clear. So if you're asking me what's clear, that's clear.
Good.
Yeah, I agree with what's been said. As I said earlier, that the fundamental point is that any process by which Scotland becomes independent requires at some point the sanction of an Act of the UK Parliament. But the content of that Act of the UK Parliament is not fixed. So the UK Parliament could amend the Scotland Act to give this Parliament power to hold referendums on a one-off basis, or permanent and unrestricted power. It could take any form. The UK Parliament could, although I think is unlikely, could delegate power to this Parliament to declare independence if it wanted to do so. So that's the one thing that's fixed. The UK Parliament has to decide what the process is and has the final word.
And the permissiveness, the vagueness, it works for both those who would wish to pursue a secessionist argument and those who would wish to retain the current constitutional arrangements?
So vagueness or constitutional silence, there's a big academic debate on this. Constitutional silence can be both helpful and unhelpful. There are circumstances in which maintaining a degree of constructive ambiguity is helpful, and there's circumstances where that becomes very unhelpful. I mean, my personal view is that the ambiguity, and Stephen and I were co-authors of that blog along with other people, that ambiguity over the power of this Parliament to legislate for a referendum had come to the point where it needed to be settled. It was no longer helpful, it was becoming obstructive, and clarifying that question was helpful. As far, more generally though, I think it remains that the fluidity and uncertainty of the process remains to some extent helpful, although I can also see arguments that it is unhelpful. So the argument that it's unhelpful would be that frustration over the lack of a clear route to independence itself becomes a constitutional grievance that fuels support for independence. That is a possibility, and if you don't want that outcome, that might be an argument for saying it's time to clarify the process. However, as we've heard from the international examples and also the Northern Ireland example, there is a real risk that clarification of the process would not be favourable to those wanting to seek independence, because it may put too many hurdles from their perspective in the way of that process. So yeah.
In balance, does the permissiveness, the vagueness, weigh in favour of anyone as opposed to a codified secessionist legal route?
At the moment, I think it's probably still beneficial, but I can see there might come a point when it's not.
I don't think the position is vague. I think it's fluid. I think it's very clear, but fluid. This Parliament does not have the authority to stage a referendum, but the UK Parliament 100% has the authority to offer one, either through Section 30 or through a distinct piece of legislation. So it's very clear, but the UK has a political constitution. We don't have a written constitution, so things come back to politics. I don't see that vague. I think it's just simply fluid and political. The
vagueness exists for the secessionists, though. In terms of route.
So the question of how you persuade the United Kingdom Parliament to legislate for an independence referendum, there are those in the room who would say that the answer to that at the moment is vague, and there are those in the room who would say that they are frustrated at that vagueness. So that's where the vagueness is. But Professor Tierney is entirely right as to the clarity of the competence of each respective parliament, and there's no disagreement between us on that.
Right. Thank you very much for your clarity and your certainty around the fluidity of the situation.
Keith.
Very quick question, which would be great to get a quick answer to. I'm generally confused. And then another point after it. It seems to be the fashion to refer to this as secession rather than independence. Fair enough. What is it we're seceding from if we agree independence?
We call it secession because that's the term that's used in international law. It's not at all a loaded term. It is coterminous with independence. I know that those who want independence in Scotland do not call themselves secessionists. None of us mean it as a term of abuse in any sense.
What would we be seceding from?
The United Kingdom.
Not the Act of Union?
No. Secession is an act in international law where a territory secedes from a state. The state is the United Kingdom. So Scotland would be gaining its independence from the United Kingdom. Scotland would be seceding from the United Kingdom. That's how it works in international law, as I understand it.
Grateful for that clarity. It does raise in my mind the question of whether it would be possible to have a legal referendum in Scotland on a question of no confidence in the Supreme Court, but that's just my own view. My point, though, is about the kind of narrative that seems to have built up, and I could be wrong on this, and please feel free to correct me, between the two referenda previously held in relation to devolution. Because rather than it being a higher bar was set, it was a lower bar that was set. And rather than it being a change of mind, it was an increase in support for that. Because in 1979, this perverse, very unusual, unprecedented rule was brought in, which allowed the votes of the dead to count towards a no vote, and putting the 40% rule in. And yet that grew over time. So I think Professor McHarg made the point, and I'm paraphrasing here, I don't want to put words in the mouth, that kind of obstruction to democratically expressed views will tend to lead to an increase in support for that view, if I'm getting that right, such that when people in Scotland voted to have an assembly in 1979, I'm just old enough to remember it, it was refused. And did that in itself lead to an increase in support over a period of time? And also to say the settled will was never a precondition of the 1987 referendum. People talk about settled, it was never a kind of precondition that was set there. So the idea we could set a precondition saying we must have, and I know you've all argued against this because it's such a vague term, the idea that we should have a settled will that meets a certain bar, that was never part of the 1987 referendum. I just make that point. I'm happy to hear any comments on it, but we should be clear about the history of the two devolved assembly referenda.
On the secession independence thing, I absolutely agree with Adam. It's simply a synonym. I use the term to emphasise the point I've continually made that, to my mind, this is not simply a constitutional question. It's a question that involves not just internal actors but external actors. It involves engagement with the international community from whom an independent Scotland would seek recognition. So I think the term secession places the act of seeking independence in that broader international context, which it should be set in. In terms of a referendum to achieve that, what are the precedents? The Supreme Court of Canada said that the rest of Canada might have a duty to negotiate with Quebec in the event of a referendum if there was a clear majority on a clear question. It didn't explain what it meant by that, but some have read it to mean possibly a supermajority, the sort of issue you were talking about, Mr Brown, going back to 1979. Another example would be Montenegro breaking away from Serbia. I think that was 2006, where a 55% majority was needed in that case. It's not universally the case by any means that a supermajority is required in secession referendums, but some argue that given the importance and the one-offness of a secession referendum, some argue that there should be a supermajority built in. As I say, it's not a universal rule, but some people do argue that, given the significance of the decision, which is very different from ordinary constitutional decisions.
But 79 wasn't a secessionist referenda. 2016 was, but 79 wasn't a secessionist referendum. Sorry.
So just a couple of points. I mean, and this is a very, very picky point. Secession is not entirely a synonym for independence, because you can have secession in circumstances, as would be the case in Northern Ireland, where the seceding territory will form part of another state, another existing state, rather than creating an independent state. And it's worth just clarifying that the right of the people of Northern Ireland to secede is only to form part of a united Ireland. It's not to form an independent Northern Ireland. I mean, on the question of turnout thresholds or supermajorities or other obstacles, I mean, the 79 referendum, the Scottish and Welsh devolution referendums are the only ones that we've ever had in the UK that have had any kind of turnout threshold or special majority, and the resentment that caused in Scotland because there was a majority, just not a sufficient majority, I think is the key reason why we've never done it again. So, there are arguments to be had in principle about whether we should have supermajorities, but I think we also have to recognise that these debates take place in particular contexts, and in the context of the UK, supermajorities have a bit of a bad reputation.
Neil, very quickly, please.
I was just on that. Clearly, supermajorities may or may not be required, but a clear outcome of any referendum that it can establish that you know, settled will of the people of Scotland would be desired, if not, you know, required in relation to a supermajority. But I think that also takes us back to the point that in the circumstances, I think, Professor Tomkins, you talked about earlier, when we had the 2014 referendum, it wasn't just the case that the Scottish Government at the time argued that there was a democratic mandate through the Scottish Parliament elections. There was a sense from both sides, not just at a Scottish Government and a UK Government level, but within Scotland, both sides of the debates, yes or no, decided that that was the time for questions to be put. And if you want that clear and concise outcome of any referendum in the future, there would have to be that consent, not just at a UK Government level versus Scottish Government level, but within Scotland, both sides, or as close to both sides of the debate as possible, because you're never going to get unanimity on that. Should I agree in that referendum? Should we?
Yes, I agree. I don't really have anything further to add, Convener, but I mean, I agree with that. I mean, perhaps one point I would just make in relation to what Keith Brown just said is that I don't think we're suggesting, certainly I don't think I'm suggesting, Mr. Brown, that that settled will has become any sort of precondition. That's not the phrase I would use. But I think the constitutional reality, as we've tried to explain it, all three of us, is that there cannot be an independence referendum without Westminster's consent. So the question is, how do you persuade Westminster to grant that consent in whatever form it comes? And the suggestion certainly from me and perhaps from others is that the way in which you persuade Westminster to grant that consent is a political process, not a legal process. It's a political process whereby those who want an independence referendum demonstrate that it has become the settled will of the Scottish people to pursue independence, or at least to have an independence referendum. And I wouldn't describe that as a precondition. I would describe that as a way of making sense, as I said earlier in my remarks, about the whole of the Constitution, the legal rules, which are now clearer than they were, and the political negotiations that happen, or the political campaigning that happen under the umbrella of those legal rules.
Okay, final question from me. And I think it was Professor McHarg, you mentioned this idea, you'll know it when you see it. I have to say, as a data scientist working at the European EU referendum, I saw it in Scotland, and I was absolutely devastated to have been taken out of the EU, given 64% of the Scottish people supported remaining within the EU. So my question is, given that that seems to have been a statement and a consensus from the Scottish people about our position, what does it say about our democracy and the state of the Union at the moment, in that Ireland received many concessions to what would happen, albeit most of it through the Good Friday Agreement, but Scotland received absolutely no concessions about some of the access to the EU that we would want?
Politics.
Fair enough.
The different treatment in Northern Ireland was driven not by any internal constitutional considerations, but by the fact that Ireland is a member state of the EU, shares a land border, and managed to make that land border a red line, a negotiating red line for the EU. If you look at the internal constitutional litigation, and there's quite a lot of it from Northern Ireland, the position of the UK Supreme Court is just as uncompromising in relation to Northern Ireland as it is in relation to Scotland. So our attempts, the Scottish Government's attempts to argue that the Sewell Convention created some sort of binding veto power over triggering Article 50. Arguments were made a whole series of arguments were made in relation to Northern Ireland, including on the basis of the principle of consent under the Good Friday Agreement, and these all failed. These were all rejected. So I think that is, it is simply a reflection of the differing political resources that were available to the Scottish Government on the one hand, and not the Northern Ireland Executive, because obviously that was actually not operating for most of that time, but to those groups in Northern Ireland who wished to maintain an open border.
I mean, no disrespect at all, convener, when I say that yours is a political question, and in a former life I would have risen to its bait, but it's not a question for a constitutional lawyer, so if you'll forgive me on this occasion, I won't. Safe to say that, you know, the constitutional position with regard to Northern Ireland is materially different from the constitutional position with regard to Scotland, and those differences are reflected in part in the Northern Ireland Act on the one hand and the Scotland Acts on the other. Northern Ireland's constitutional future is wrapped up in the Good Friday Agreement or Belfast Agreement, which is an international agreement with another state, right? And we are talking about, you know, states and secession, and the difference between a state and a territory that is not or not yet a state is absolutely material, not only in international law but also in constitutional law with regard to Northern Ireland's future. And so, just as I said in answer to Patrick Harvey's questions, we can learn a lot from comparative experience, but we can't necessarily transplant other people's experience to our own. Scotland's constitutional journey, Scotland's constitutional route, and Scotland's constitutional future are Scotland's, and they're not necessarily the same as those of Northern Ireland or any other part of the United Kingdom.
Okay, thank you. Do you wish to comment, Professor?
A very
Keith?
final reflection, which is, I know it's really frustrating when lawyers come along and they seem to be telling people what they can't do. One of the things about being a constitutional lawyer in the United Kingdom, actually, compared to being one in Germany or America, where the constitution is almost impossible to change and where secession is not allowed, is your job is actually to tell people what they can do. We have a political constitution. It might not be one that everyone around this table particularly likes, but the United Kingdom constitution is incredibly flexible. And these questions are political, but if you make the political argument, all you need to get the constitutional change is a straight majority in the House of Commons. There are not many constitutions in the world that work like that, but within our system, it does work like that. And you can go down the road, even so far as breaking up the state on the basis of a straight majority in the House of Commons. So yes, it's political, but it's certainly not unachievable for people who want to make political arguments.
Thank you. Thank you all for your attendance this morning. We are now going to have a very short break before we move into private session, because we're a little behind time for what we'd hope to be. Thanks.